Okay, now we are on live stream. So for those just joining, welcome. We are glad to be here. My name is Elise Kepler, and now we are on live stream. Great. I'll start one more time. My name is Elise Kepler, and I am the Executive Director of Global Justice Center. And we are gathered here today for the first of a webinar, three-part webinar series, The Role of Conscience, Religion, and Belief in the Context of Abortion. It is truly an honor to have the panelists, the esteemed panelists here today with us on this important topic. Before we start, I just wanted to say a brief word about Global Justice Center, as some of you may be encountering the organization for the first time. Global Justice Center, which has organized this series, is a feminist international human rights organization. We were started in 2007 by Janet Benshoff. Some of you may know that Janet Benshoff was a legendary reproductive rights advocate in the United States. And she started Global Justice Center after also starting Center for Reproductive Rights. The decision to start Global Justice Center represented a desire on her part to go both more broad and more narrow. More broad in the sense that she wanted to continue efforts on reproductive autonomy and reproductive rights and justice, but in the context of the larger project of gender equality and situating this issue in that effort. More narrow in the sense of digging in and focusing on the power of international law and how that could be used to advance gender equality through innovative, progressive interpretation and application of international law. Today's series really honors that legacy and that commitment as we look to think about how right to conscience can be used to support abortion provision, turning some traditional arguments on their head and looking at the challenges of conscientious objection and how it has been deployed as a barrier to access. I am looking forward to a rich discussion, thanks to the leadership of Jamie Gear, our senior legal advisor, who has put this together, and the incredible panelists who will be presenting today. I'm so thrilled all of you are here to attend, and I'm going to pass this over to Jamie now to get us started in earnest.
Thanks, Elise. Hello, all. My name is Jamie Gear, and as Elise mentioned, I'm a senior legal advisor with the Global Justice Center. Today's webinar will focus on the global scope and impact of conscientious objection to abortion, highlighting emerging global and national research that demonstrates the impact of unregulated or insufficiently regulated conscientious objection. We're also going to provide an overview of international human rights norms and standards around conscientious objection that can be relied upon to promote effective regulation. So before we get started, I wanted to cover a few housekeeping points. First, as you know, this webinar is going to be live streamed on YouTube to ensure wide access. We also will provide a recording afterwards for sharing with your networks. In an effort to keep the discussion moving and for purposes of security, audience participation is going to be limited to the Q&A function. If you have questions, please feel free to post them there, and we will try to address them towards the end of the webinar. And audience members who need Spanish translation, you can use the Zoom automatic captioning and translation tools. Now, before we get started, I also want to provide a roadmap of where we're going with the discussion. First, we're going to hear about refusals of abortion care based on conscience, religion, and belief from the perspectives of international legal and professional ethical standards. Second, we will be provided an overview of global and regional trends and new research and tools that advocates can use to challenge conscientious objection. And finally, we will hear from some country-level experts that will talk about the impacts of refusals of care in Mexico and Croatia, and discuss the challenges of such refusals of care following law reform in context with liberal laws and despite fairly clear international standards on abortion. Following each of the presentations, we will have time for Q&A. And now, before I turn it over to our esteemed panelists, I'll provide just a bit of background on why we're here today. So we have seen for decades that refusals of abortion care based on conscience, religion, and belief have been an ongoing barrier to essential care worldwide. Such refusals occur in both countries with restrictive abortion laws and liberal abortion legal regimes. Refusals of care tend to increase even after liberal law reform has occurred as a form of backlash. Now, evidence confirms that conscientious objection leads to delays in some cases, denials of abortion care, stigmatization, and other harmful impacts on pregnant individuals. It can also have significant impacts on medical providers, including increased workloads, stigmatization, and personal ethical challenges. So, as a feminist human rights organization, the Global Justice Center is committed to advancing and advocating reproductive autonomy as a human right. Along these lines, this webinar series has been organized to explore the impacts of conscientious objection at the global, regional, national levels, to challenge the systems and structures that enable refusals of care, and shift minds and hearts about abortion care and support, which can in fact also be an expression of individuals' conscience, religion, and belief. Following today's discussion, we're going to host a second webinar in October, which will focus on unregulated conscientious objection in the United States amidst diminishing abortion access around the country, and strategies advocates can use to challenge such refusals of care. Our third and final webinar will take place in November, focusing on abortion provision and support and pregnancy decision-making as an expression of individuals' conscience, religion, and belief. This third webinar is going to be building off of an expert brainstorming GJC held in March of this year, where we explore reframing the debate around conscience, religion, and belief, which is all too often focused on exempting medical professionals from providing care and presumptions that conscience, religion, and belief uniformly conceive of abortion and reproductive autonomy as negative or wrongful. Experts who attended the brainstorming considered both the possibilities and the limits of asserting the right to freedom of conscience, religion, and belief, that it can be relied upon to expand abortion access and to protect the rights of abortion providers and those who support others to obtain services. We will be sharing an outcome report from that brainstorming soon, along with additional information on each of these webinars. Now, without further ado, I'd like to jumpstart the discussion. We're going to start the first section of the webinar, where we hear from two panelists who will provide an overview of the international legal and professional ethical standards regarding conscience objection, positive practices, and the experience of and impacts on medical providers. Our first panelist for today is Claudia Flores. She is a clinical professional of law at Yale Law School, the director of the Allard K. Lowenstein International Human Rights Clinic, and director of the law school's Orville H. Shells Jr.'s Center for International Human Rights. She is also currently the chair of the UN Working Group on Discrimination Against Women and Girls, where she has been a member since 2023. Ms. Flores is also the co-host of Entitled, a podcast that explores global debates around human rights. Her teaching, scholarship, and law practice have focused on international human rights, constitutional reform, global inequality, and state accountability for failures of good governance. Prior to joining Yale Law School, Ms. Flores was a clinical professor of law at the University of Chicago Law School and the director of the Global Human Rights Clinic. I turn it over to you, Ms. Flores.
Thank you so much, Jamie. Can everybody hear me? Great. Okay, so I'm gonna set a little timer for myself to try to be respectful because I'm very excited to hear the other panelists. So thank you so much, and thanks to the Global Justice Center for inviting me as the chair of the working group to today's conversation. I'm really honored to be the first panelist in the discussion and to try to set the stage for international human rights law and the application of conscientious objection. I'm especially glad to be at this webinar that has such a diverse audience of legal experts and medical practitioners and civil society actors. Conscientious objection and the rights restriction that it generates, which is part of what I'm going to talk about, isn't really just a legal problem. It's also a practice problem and an implementation problem. And so it requires advocacy from all of these different sectors in order to make sure that rights continue to be respected, even in states where it's recognized. So I'm gonna share my PowerPoint, which I think will just help illustrate and provide like a useful visual. Am I sharing my screen now? Okay, great. So let me just pass this first one here. Okay. Okay. So, and I think the other thing that I'll say that I think many of you know is that the working group actually did a guidance document on conscientious objection in 2024. So we think it's quite an important issue and really encourage advocates to read the guidance document and rely on it. It's soft law under international law, so it can actually be quite useful in trying to explain to states what their obligations are under conscientious objection. So I think the important points for us, and just to make sure we're all on the same page, conscientious objection describes a situation where a healthcare worker or an institution refuses to provide abortion services or even information on the grounds of conscience and belief. And there are some states that actually recognize this. There are some states that prohibit it, and there are some states that are recognizing it while ensuring that they are effectuating the rights of women and girls to health services and reproductive services. So this practice is what we call it because it's not a right in and of itself. Often institutions claiming conscientious objection will ground it in freedom of religion and belief. But conscientious objection specifically is not its own right. So it is a practice that is often grounded in this interpretation of a right. But it is posing significant challenges in certain jurisdictions to the realization of sexual and reproductive rights, particularly access to abortion. And it's been under-addressed in the international arena, which is why we issued this guidance document. And the main conclusion, I'll just tell you, the short version of the guidance document is that while states may adopt laws and policies that protect freedom of religion and belief, international human rights law requires them to ensure that these protections don't interfere with the rights to health and the rights to reproductive services and to safe abortion services. So if a state is going to recognize conscientious objection, it needs to do so in a way that ensures that that all individuals have their rights to health and their access to the services that are encapsulated in the right to health. Okay, so just a very quick overview of state practice. As I said, conscientious objection, its recognition is a widespread, but not being addressed on a global level. There's very poor and inconsistent regulation, which leads to a denial of services. And sometimes it's an explicit denial of services, and sometimes it's just in practice because healthcare professionals are sort of being allowed to discourage or to not provide information based on their freedom of conscience. And so in practice, it's making it hard to access these services. There are some examples, for example, in Poland, of pharmacists refusing to provide contraception. There's the permissive model in Argentina, Colombia, and Zambia, where conscientious objection is recognized in constitutions, statutes, medical ethics codes, or judicial decisions. There is also other states that restrict or prohibit its use in reproductive health care, such as Finland, Sweden, and Ethiopia. And then a third group of states tends to take a mixed approach. This is Mexico, Norway, New Zealand, where they permit objection, but they require safeguards like referral obligations. And that's really the model that we think is the most effective for states that decide that they want to recognize it. Just to give you a little bit of an illustration from Poland, for example, during the working group's country visit to Poland, we documented how some pharmacists were invoking conscientious objection, even illegally, to refuse emergency contraception. And this meant that victims of sexual violence were often denied emergency contraception or antiretroviral drugs, including at police stations. Our report highlights how these refusals, coupled with weak enforcement of laws, create systemic barriers to care. So that's just an example of how conscientious objection has played out in a particular context. And please excuse me, my voice is coming back from being ill, so hopefully you can understand me. So as I said, the working group's position is that, well, we've consistently affirmed that conscientious objection can never be used to override women's rights to health and autonomy, and it's not a balancing act. So a state can decide that it wants to recognize it, but these rights are not in tension. So if a state wants to recognize conscientious objection, they need to fully effectuate the rights of women and girls to reproductive health care. And that's a really important point to continue to make, because often efforts to undermine human rights try to pit them against each other and, sort of interpret the inability to actually fully effectuate the rights while recognizing the rights, which is rarely true. So we see three worrying trends. One is a lack of referrals. So only 29 countries explicitly require timely referrals. Misuse, which is that objection is often invoked inconsistently under ambiguous laws or even on inauthentic grounds. Persistence despite reform. So refusal can continue and even increase despite legal reforms that are intended to expand access to reproductive health services. And so the working group has underscored that such refusals, even when unaccompanied by alternatives, disproportionately harm women in marginalized situations, forcing some into unsafe abortion. And so we have advocated for conscientious objection to be strictly limited to the individual medical provider directly involved in the procedure, and only when accompanied by clear and enforceable alternatives for the patients. And that guidance, we've insisted, needs to be very specific so that it's not diverted from in particular situations. Of course, this is never a surprise, but conscientious objection tends to have a disproportionate impact on poor, young, rural, disabled women, those from minority groups or marginalized groups that are least able to overcome denials, either because they have limited access to alternative services or because they're not going to challenge a medical professional and sort of demand that medical professional effectuate their rights. So this compounds inequality and exposes the state to liability under international human rights law, of course. There are some positive practices that we've seen. Ethiopia prohibits conscientious objection outright. Finland and Sweden decline to recognize it in reproductive health care. Norway imposes a duty on public hospitals to ensure abortion is available regardless of individual refusals. Mexico, Colombia, and New Zealand require objectors to disclose their objection early and refer patients to another provider. And at the regional level, the African Commission has clarified that states must guarantee access despite third-party consent requirements or conscientious objection barriers. So these are some positive practices that we're seeing develop. I want to share with you, because this is how the working group is trying to put a framework around state obligations under international human rights law to achieve substantive equality, and it's very applicable in this context. So those of you might be familiar with another guidance document that the working group issued recently on substantive gender equality that provides a framework based in academic literature that sort of explains to states in a more detailed way what they need to do in a holistic manner to effectuate substantive gender equality. And so in the conscientious objection context, it's useful to put state obligations within this framework. So, for example, and it's CREATE, countering harmful norms, redressing economic disadvantages, eliminating legal and structural barriers, adopting proactive laws and policies, transforming institutionalized patriarchy, and enhancing participation of women. You can look at this more closely in our report. But we've applied it to the conscientious objection context. So, for example, countering harmful norms would require a state to challenge stigma and discriminatory norms that distort abortion rights and medical duties. And so we sort of have gone through to give a little bit more specific directives, because one of the things that we've found is that states will often do one thing but then ignore another. And so then the right is not effectuated because they're not taking a holistic approach. And I'm happy to share this because I know I'm moving through this rather quickly to make sure that I meet my time, and I'm already over just 2 more slides. So working group recommendations have been, as I said, to limit conscientious objection to direct providers only, to require referral systems, registration, to have emergency exemptions, to remove third-party consent barriers, to ensure non-discriminatory insurance coverage, and to promote gender equality in health policy more broadly. And our key takeaways in really thinking through this is that, and the central message is just that freedom of conscience can't be implemented in a way to deny healthcare, and that any regulation that states do must safeguard and effectuate women's rights in the health context, and that's really, really the priority. And what's needed really is for the state to commit resources and to create an implementable mechanism and not just leave it to the individual institutions. So I think I'm just going to leave it there and happy to answer questions, but we really did intend for this to be a call to action and hope that that partners can monitor because this is sort of a really difficult this is a difficult phenomenon to really note because it's happening at such an individual level, and we will continue also to highlight it in our communications and trying to do what we can to support all of your efforts. So I will just end there. Thank you so much.
Thank you so much, Ms. Flores. We are incredibly grateful to the working group on developing these useful resources for advocates. Next, we would like to turn it to Dr. Laura Gil, who's an OBGYN in Colombia. She's also an abortion provider and an advocate, as well as a trainer and speaker on safe abortion access. She's the co-founder of Grupo Médico por el Derecho a Decidir, GDC Colombia, which is part of Causa Justa, the movement that achieved depenalization of abortion in Colombia. Dr. Gil is the chair of the Safe Abortion Committee for FIGO and the advisor for the Sexual and Reproductive Rights Committee for the Colombian OBGYN National Society. I turn it over to Dr. Gil.
Thank you so much, Jamie. Please confirm if you can all hear me well. Okay, thank you. So first of all, I want to thank Global Justice Center for putting this together, this important webinar. And I want to thank all my colleagues from the Safe Abortion Committee for the rich discussions that have brought us here and are the base for FIGO's statement on conscientious objection, which I will try to summarize in this few minutes. Then I'll share the Colombian experience at the end, and I will share some of the practical recommendations from the committee in order to address conscientious objection in the right manner. So first of all, I want to give you a definition of conscientious objection, because a lot of times we confuse it and we mistake it with other attitudes in the providing of services that are not conscientious objections. So conscientious objection is a mechanism. It's not a right. It's a mechanism through which a person can refuse to perform a task or to comply with a duty that is natural to his or her role because of a personal, moral, or religious belief. That is an impediment. I mean, something that you cannot do, and it's something that you should be doing because it's part of your duty, of your professional duty. So when it comes to abortion, it translates in the possibility for health professionals to not perform abortions when they are requested to. But that's it. Actually, some may also include the possibility of not giving information to patients that request abortion, but clearly that is not okay because it may harm people not to have enough information. And let's remember also that denying information is not okay. It's not part of conscientious objection, because what an objector is objecting to is to ending life, to ending intrauterine life by an abortion. So that does not include information, of course. This objection cannot go further and limit others' decisions or others' rights, especially regarding their own body. This is, as I just said, this is a mechanism, not a right. It's an option that can be invoked in order to protect one's beliefs or right to freedom of conscience, but it's not a right itself. It is essential to understand that conscientious objection cannot limit all the other fundamental rights that are at stake when a woman or a girl needs an abortion, such as dignity, health, life, autonomy, and others. Conscientious objection also takes place in the context of a very unbalanced relationship of trust in terms of authority and power. I mean, patient and doctor relationship, in which all efforts should be made not to compromise the autonomy and the welfare of the less empowered person involved, that is the patient or the woman or the girl or the person that's pregnant. But sadly, conscientious objection has become a widespread barrier for many women and girls to access the care they need. But I want to drop here a question. Is conscientious objection really a barrier? Or is its misuse what results in undue burdens for women and girls? So I'll dwell in this further. So I also want to bring your attention before I go to our statement on the false dichotomy around abortion and conscience. So when we talk about conscientious objection, we almost try to imply, or not we, but many people try to imply that abortion goes to one side and then conscience goes in the opposite direction. And this distortion is mediated by stigma, and it demerits conscience as a reason to safeguard women's rights, and fails to recognize that abortion providers are driven by their conscience and do so because they believe that they are providing good ethical care and couldn't do otherwise, and therefore are conscientious providers. Also, when we dichotomize conscience and abortion, it sells the wrong idea that when a person decides not to perform abortions, it is because of a higher moral status or for conscience-based considerations only. But in fact, many abortions are denied because of stigma, administrative barriers, unwillingness, and very often is disguised as conscientious objection. So I want to bring attention to this because we want to recognize abortion providers as conscientious providers. Their conscience tells them that's the right thing to do. So based on this definition and that other concept that I just said, the FICO Safe Abortion Committee positioning on consensus abortion calls us to recognize that our primary duty as doctors is to treat, benefit, and prevent harm to our patients and recognize their autonomy. And make sure that they get what they need according to an informed consent, and that means all options that have been objectively exposed. So continuing the pregnancy, abortion, adoption, and any other option. So those decisions are truly informed and autonomous. Let's remember that abortion is an essential service, and therefore it cannot be denied and should be provided and informed to all of the extent of the law of each one of the countries we live in. And please, I want to bring your attention to this. Here we have benefit, prevent harm, and respect. And those are essentially bioethical principles that we must attach to. This is not just our duty as professionals, it's our ethical duty as citizens and as humans. So what happens if we don't agree with abortion? Nothing. My patient's rights do not change because we think differently. Conscientious objection is not about agreeing or not with abortion or with someone's decision to have one. Of course, by no means could someone make someone perform an abortion. And if it is against her conscience, and that's why they refuse, so their right to freedom of conscience is not harmed, so they must be able to refuse performing the abortion. But since essential services cannot be denied, then they must provide referral objectively and timely, not whenever they feel whatever they want to inform or whenever they want to refer. So I avoid harming my patient. Conscientious objection also cannot be invoked if there's risk to life in emergency situations, and also in cases when women seek care of for an abortion or after an abortion, or when there is no other responsible for the care, or when there's no reasonable option for referral. But this last limit is mostly overlooked in many places. Neither it can be invoked by other professional different to the one performing the abortion. That is, that no administrative support or anesthesiologist or other specialists may invoke conscientious objection, or not even non-persons as institutions, given that only persons have the attribute of conscience, and institutions may have an ideology, policies, but not conscience. So institutions are all obligated to provide abortion. So any actions that end up in delays, burdens, and harm cannot be acknowledged as part of conscientious objection. And I think that's our big confusion. Sometimes we say that women could not access an abortion because of conscientious objection. That was not conscientious objection. That was denial, unjustified denial of services, because nothing justified not to take care of a person that is in need of an essential health service. And that is the reason why conscientious objectors are responsible for planning in advance in case they are required to provide an abortion, and they must guarantee its provision, otherwise they may cause harm. And in that case, when they guarantee the referral and the care, they are using conscientious objection in the right way. So when unjustified denial of health services takes place, there are consequences for women, of course, because there's decreased healthcare quality because of delays, of lack of continuity in care. There's psychological sequelae, even when they are provided afterwards, because they feel judged, because they feel morally inferior in front of a person that has authority over them and has just told them that that is against their conscience, as if their conscience was more important than hers. It can also result in forced motherhood and complications and death because of unsafe abortion, but also has consequences for providers. There's work overload for those that are not conscientious objectors. There's stigma, and there's professional isolation. We often see segregation of services to a different area, to a different clinic, and that is all because conscientious objectors become the status quo. I mean, the right way to be a doctor, and in a lot of places we can see that. So I want to share with you very quickly our experience in Colombia. In my whole lifespan, I've been able to witness all of the spectrum of abortion law. Before 2006, we had an absolute ban, then we had a partial legalization with exceptions. And then in 2022, we achieved depenalization upon request up to 24 weeks. And after that, with exceptions. One of the main barriers that we've seen, but because this doesn't mean this evolution does not mean that we have everything solved. There's still a lot of barriers, but one of them is conscientious objection abuse. So I want to share Colombian regulation as a nice example of what happens when a country takes the recommendations, FIGO's recommendation in their own regulation and show to you how it works. So our regulation has been mediated by a constitutional court, which is a high court that rules accordingly to fundamental rights, which is a huge advantage in my country. So conscientious objection must be individual, not institutional, but there's still a lot of faith-based hospitals in Colombia that still systematically deny abortions. That is something that I don't know if we are going to be able to fix someday. It applies only for direct providers, as I just said, it was the standard. There's the obligation for effective referrals. It has to be previously informed, as Claudia just showed us in her presentation. So we must tell our boss or our OBGYN head that we are conscientious objectors, so they can arrange in advance in the shifts or the arrangement of the hospital. It's not applicable if undue burden. This usually applies to emergency situations, life-threatening situations, but also applies to long-distance traveling for women that live in far-apart places where there's no conscientious objectors, there's no conscientious providers available. Should not this result in discrimination, not for the woman or the doctor who is objecting. And the system must ensure sufficient providers in every service, not just abortion dedicated services. And there's two latest developments that I think are very important. The first one is just a sentence that's been there since the beginning, but the Constitutional Court managed to put it in a simple sentence that I think it's important. And it's conscientious objection can be invoked if and only if provision can be guaranteed. And a new one that I think has been very helpful is that conscientious objection does not apply to prescription of abortion medication. Why? Because prescribing a medication does not end prenatal life. Remember that that is what a person can object to. They cannot object to person's decision, but just terminating the life of that pregnancy. So prescribing a medication does not automatically end that life. So the Ministry of Health has come to the conclusion that it does not apply. So just to finish, we made a survey in 2021 asking about conscientious objection to a group of OBGYNs. And we end up having a 25% of true conscientious objectors. But when you ask them what strategies they thought would be useful to overcome conscientious objections, some of them thought creating a separate specialized services. So we start seeing the segregation of services as happened in the United States that have a good side, but also has a really bad side of isolation and being targets for hyperregulation. Also, some say hire additional personnel, allow institutional objection. Others said that we should all systematically deny abortions because we should all be conscientious objectors. Some said something intermediate, like create listings so we could plan accordingly for the shifts, for the OBGYN shifts. And some say, let's make provision compulsory. Let's make everybody be obligated to provide abortions. So this is a little bit like what Claudia showed in Finland and Norway. So as you can all see, these solutions all come from outside. Everybody, all conscientious objectors are looking for the solutions outside of them. And I think that conscientious objectors are responsible for arrangements in advance. It's not the hospital obligation. It's not the country's responsibility. It's their responsibility because they cannot comply with the whole load of their duties. And when I see this dichotomy between denying all abortions or obligating everybody to provide abortions, I have a question and I want to drop it here too. And it's, what about believing in human capacity for staying true to one's beliefs while avoiding harming others? So I'm going to end here and remind you of FICO's recommendations are to sensitize, educate, and train in a human rights framing. So there's no discrimination, but mainly so people, when they are in their medical school, nursing school, reflect on what really is being a conscientious objector. It's not just not wanting to provide abortions. It has to be deeply rooted in your beliefs and not just something that you don't want to do because there's stigma. Advocate for strict regulation and that there's accountability if it's misused. And I think that's one of the things that have been missing in Colombia. We don't have that strong accountability or consequences when conscientious objection is misused. It should apply only to possible direct providers, and it should have clear limits. And we have to institute strong referral services. And of course, avoid barriers to safe reproductive health services. And our last recommendation, we need more conscientious providers. Thank you.
Thank you so much, Dr. Hill. We really appreciate it. We're now going to turn to the second portion of our webinar. We hear from two civil society advocates who will introduce global and regional trends regarding conscientious objection laws, policies, and practices, and some resources and research that advocates can rely upon to challenge conscientious objection to abortion. First, I'll turn it over to Augustina Ramon Michel, who's an associate researcher at the Center for Studies of State and Society, or CEDES, where she conducts socio-legal work in health. She's also a professor at the University of Palermo. Ms. Ramon Michel is also the co-founder of RADAS, a network of safe abortion in Argentina. I turn it over to you, Augustina.
Good morning, everyone. Thank you, Jamie, and the Global Justice Center for putting this together. The title of this webinar really highlights a core issue, and it's quite expressive of what is going on. Conscientious objection as a global barrier to an abortion. But then there is the subtitle, Human Rights Norms and Standards to Guide Regulation, which hints that we do have some trust in what the law can do. So is there not skepticism about the law? Perhaps not even the liberal faith in the law, but something similar to hope. For me, for sure, it's more like hope, following the tradition of Latin America relationship with law, some hope of what law can do. So today I want to show how different national legal systems around the world are trying to respond to these abuses of conscientious objection, some of them mentioned by Claudia and Laura. And I think it's a way to start exploring what are law responses to this social problem, at least in the text, no? So then Dana Repka will tackle the international regional human rights standards, all of which is part of a CEDES and REDAS project in mapping global norms. So we have analyzed over 400 regulations across 200 countries. And while, of course, the picture is quite complex, some clear trends emerge. Let me highlight a few. First, as abortion has become liberalized, conscious clauses have emerged. So this relationship between abortion right and conscientious clauses has a long history dating back to the 60s, and is a regularity regardless of the specific names that it took. So here in the presentation, you can see that at the beginning, it was to call the right to refuse or to refuse, to reject, then conscientious objection, and in this new century, the right to conscientious objection. So as the right of abortion have gained momentum, also the right to conscientious objection, formulated in that way as a right. The second trend is that of the 90 countries, around the 90 countries with conscientious regulation, nearly all, 97%, allow conscientious objection. So, and you have three notable exceptions, Finland, Sweden, and Ethiopia, which explicitly prohibit conscientious objection. Then, of course, you have some countries that do not regulate conscientious objection, so they don't permit it, they don't prohibit, right? But most of these countries are in countries where you don't have abortion policies. Then a third trend. So you have a very extended recognition of conscientious objection, but the fact is that most laws, most judicial decisions recognize conscientious objection as an individual right. Only a few countries like Chile, United States, France, Uruguay explicitly allow institutions to refuse. Moreover, I will say that courts usually reject institutional conscientious objection, then tend to recognize and emphasize the individual dimension of this right. The fourth trend I would like to show to you is that most countries impose limits. This is a highly different view from what Claudia presented. So maybe we can have a conversation then, because in our research, we find that most of all countries recognize some sort of limits. Of course, the question is what kind of limits? So for instance, refusal cannot apply during emergencies, and the duty to refer patients are the most common. Some courts like Colombia, Mexico, and Ecuador have even ruled that broad and limit conscientious objection violate women's human rights. So having a conscientious clause without limits is unconstitutional. That is what have been said by the Mexican court, by the Colombian court, and also in a slightly different way by the Ecuadorian, the Constitutional Court from Ecuador. So, and the last trend that is not yet a trend, is more like a new development, is what we call the institutional safeguard in conscience clause. So, initially framed as an individual right, the focus has slowly shifted toward this institutional responsibility. So, indeed, while initially framed as an individual right, the focus has progressively moved toward the responsibility of the healthcare institutional to ensure access to essential service. So this shift is reflected in the inclusion of institutional safeguard in the conscience clause of Argentina, of Colombia, such as a referral system and the obligation to keep an adequate number of healthcare professionals willing to perform abortion. So you have the recognition of conscientious objection, but also an obligation posed into the head of clinics, hospital, and other health services. Several Latin American countries are pioneers in the design of this institutional safeguard by using evidence regarding the abuse and political exploitation of conscientious objection. Some of these have been mentioned by Claudia and Laura, and its impact on some women. Although these arguments are not yet, what we find is that they are not yet developed and remain under theorized, the institutional approach recognizes, I think, that conscientious objection cannot be viewed as only an individual issue, an issue between a doctor and a patient. It has to be in a more structural way, or at least in a more institutional way. The extent to which this institutional safeguard represent a different conception or framework remains an open question. So we can have this development in some conscience clauses, but still the framework is an individual framework, a very liberal framework, or we can be seeing what could be in the future something different, a different framework. But as I mentioned, it is an open question. And in fact, it's part of our work, right? To development, all the people that are here in other places, to develop a change in the way we see conscientious objection that is still very individual. For now, what we see is like an accumulative strategy. We have these institutional obligations that are supplementary to individual obligations and limits, but not necessarily, as I say, indicate a major shift in how lawmakers perceive conscientious objection. In the Q&A, I can continue this conversation. Now I will put in the chat the global map, because it was a lot of information. So what we did was to put all this information in a global map, and we have just a paper was published with some of this information, and another is coming to have this conversation with all this information regarding all these 200 countries. Thank you very much.
Thank you so much, Augustina. Now we'll turn it over to Dana Rebka, who's an Argentinian lawyer and researcher specializing in sexual and reproductive health law. She's currently pursuing an LLM at the University of Toronto with a concentration on health, law, ethics, and policy. Ms. Rebka works at the International Reproductive and Sexual Health Law Program at the University of Toronto and at the Dalai Lama School for Public Health, also at the University of Toronto. Her work is grounded in feminist theory and focuses on comparative and empirical research on abortion access and healthcare providers' conscientious objection. Ms. Rebka co-founded the Youth Network for the Right to Abortion in Latin America and the Caribbean, a platform dedicated to amplifying youth voices and reproductive rights advocacy across the region. She has been recognized for her academic excellence, receiving the University of Toronto Faculty of Law Fellowship and the Graduate Fellowship in Reproductive Rights and Women's Rights in the developing Southern countries. Ms. Rebka's current research explores the impact of informed consent regulations on adolescents' access to sexual and reproductive health services. I turn it to you, Ms. Rebka.
Thank you, Jamie, for that kind introduction. I'm going to share my screen. There you go. So, thank you so much, everyone, for being here. And thanks especially to the entire Global Justice Center team for convening such an important and timely conversation on conscientious objection as a global barrier to abortion. In the next 7 minutes, I would like to address as comprehensively and as accessibly as possible one simple but crucial question. What do international and regional human rights standards actually require when a healthcare provider involves conscientious objection in abortion care? To answer this question, I've run a research project I have the privilege of contributing to. It was led by the Center for the Study of State and Society Center, an independent research institute in Argentina, in collaboration with Human Rights Watch. For this research, we carry out an extensive desk review. We systemically analyze primary legal sources at the international level, examining 13 conscientious international court cases and 53 non-binding instruments, including concluding observations, general comments, recommendations, and other declarations that explicitly address conscientious objection in healthcare and particularly in abortion care. These documents were issued by the United Nations Human Rights System, as well as 3 main regional systems, the Inter-American, African, and European systems. This is today the most comprehensive effort to map how international and regional human rights standards address conscientious objection in healthcare. We will be publicly launching this project next month in a policy brief with a special event on October 16, where we will have the honor of featuring Jamie as one of our panelists. Our goal with this document was to synthesize these diverse sources, identify areas of emerging consensus, and in doing so, provide a framework to help national laws and policies regulate conscientious objection in a manner consistent with international human rights standards. So, what do we find? When we examine all the international and regional human rights systems, we observe that courts and monitoring bodies are becoming increasingly consistent in their interpretation of conscientious objection in healthcare. From this review, 3 key points of agreement stand out. First, international law does not require states to recognize conscientious objection for healthcare providers. Second, if a state do decide to allow it, it must set clear limits so that conscientious objection never becomes a barrier to legal health services. And third, conscientious objection is strictly personal. It can only be exercised by individual healthcare providers, never by institutions. These are the 3 points I will focus on my presentation. So let's start with the first point. There is no international obligation to recognize conscientious objection in healthcare. No treaty, no convention, no court decision requires state to allow it, not in general and not for in abortion care. In fact, international law mentions conscientious objection only in the context of military service. For example, in Article 8 of the ICCPR and Article 4 of the ICHR. The European Court of Human Rights made this clear, particularly in Rima versus Sweden. In this case, the court upheld Sweden's refusal to employ a midwife who would not perform abortion, ruling that limiting her freedom of thought, conscience, and religion was proportionate and necessary to protect women's health in a democratic society. So the takeaway here is simple. States are free to restrict or even prohibit conscientious objection when needed to ensure access to healthcare. Second, when a state do allow conscientious objection, human rights bodies are also very clear. It cannot become a barrier to lawful care. In fact, 58 international pronouncements require states to impose some form of limit on conscientious objection. This creates two types of obligations. First, duties that fall on individual providers. And second, as mentioned, mentioned by Agustina, what we call institutional safeguards, which basically are duties placed squarely on the state to make sure that conscientious objection does not obstruct access to care. So on the provider side, on these limits that are imposed on individual healthcare providers, human rights bodies agree on 4 main duties. First, there's the duty of timely and effective referral, as mentioned by Laura Hill. Every human rights body that has addressed conscientious objection includes this requirement. If a provider objects, they must refer the patient to another competent, available, and willing provider in the same jurisdiction, and they must do so without delay. Second, there's the duty to inform the patient of their rights and options. At least 10 pronouncements explicitly require that providers give accurate information, regardless of their objection. Third, there's the duty to disclose the objection in advance. Providers must inform the patients in a timely manner if they plan to object. And finally, human rights bodies across all systems agree that conscientious objection cannot be invoked in emergencies. So in cases where life or health are at serious risk, the duty of care prevails the provider's personal objection. But beyond these individual duties, states have their own obligations, what we call these institutional safeguards. These are not abstract principles, but concrete duties that require states, for example, to regulate conscientious objection clearly and in writing with transparent procedures. Second, human rights bodies also consistently recommend that states explicitly prohibit institutional objection to prevent entire hospitals or clinics from refusing services and creating systemic barriers. Third, they also require states to set up referral mechanisms that actually work in practice, not just on paper, so that patients can obtain proper access to care. Fourth, states also have a duty to guarantee that there are enough providers willing to offer abortion care. This may include targeted hiring policies in public services when necessary, as I showed with the Rima versus Sweden case. And finally, states must monitor how conscientious objection is used and sanction abuses or delays. And let's go to the last consensus. The evidence here is unanimous. Conscientious objection can only be invoked by healthcare providers. In our review, as mentioned, we analyzed 67 international and regional decisions, both binding and non-binding, and not a single one recognized the possibility of institutional conscientious objection. The United Nations Special Rapporteur on Freedom of Religion or Belief has stated clearly, conscientious objection, if it's recognized at all, should be permitted only for individual medical providers. This interpretation has been echoed by CEDAW, CESCR, CRC, the Inter-American Commission of Human Rights, among others. The African Commission has gone even further, specifying that conscientious objection must be limited to health personnel directly involved in the provision of a specific service, and that institutions cannot claim this right. This is a crucial safeguard because allowing institutions to reject will create systemic-wide exceptions that can undermine access for entire population, especially women, girls, and marginal groups living in areas where there are few alternative facilities. So, in sum, international human rights standards are really clear. There's no international right to conscientious objection in healthcare, and when a state allow it, it must be narrowly defined, strictly individual, and supported by strong institutional safeguards so that no one is denied, delayed, or misinformed when seeking lawful abortion care. Thank you so much.
Thank you so much, Dana. We're now going to turn to the final two presenters who will talk about country-level examples of the impacts of conscientious objection in both Mexico and Croatia. We'll discuss the challenges of combating conscientious objection following law reform in context with liberal laws, and despite somewhat international clear legal standards on abortion. Our next speaker is Dr. Gustavo Ortiz Milian, a research professor at the Institute of Philosophical Research at the National Autonomous University of Mexico, or UNAM, and a member of the National System of Researchers of Mexico's Ministry of Science, Humanities, Technology, and Innovation. He holds a PhD in philosophy from Columbia University in New York, and he's been a visiting professor, visiting researcher at the University of California, Berkeley, Duke University, and Oxford University. Dr. Ortiz Milian is the author of the books The Morality of Abortion and Abortion, Democracy, and Empowerment, both published in Spanish. He's co-edited several other books, Among the Mind, Language, and Morality, and COVID-19 and Bioethics. Dr. Ortiz Milian is also the author of over 100 peer-reviewed articles, book chapters, and critical book reviews. I turn it to you.
Thank you, Jamie. Thank you for having me. It's an honor for me to be here. I want to share with you a presentation. Okay, I'm going to talk about the situation of conscientious objection in Mexico. I believe that it's a very interesting example of how to regulate or not regulate conscientious objection, and there are some things that we can learn about the Mexican case. Let me start telling you about the situation of abortion law in Mexico. In 2007, abortion during the first trimester of pregnancy was decriminalized in Mexico City, just in Mexico City. Yeah. This abortion, oops. I don't know what happened with my presentation. Are you able to see it?
Sí, pero como no proyectándose, Gustavo, como que faltaría, pero sí la vemos.
Okay. Like something happened here with my computer. Okay. Well, so abortion was decriminalized in Mexico City, and then this abortion reform was challenged by the federal government, which was a very conservative government at that time. The whole issue ended up at the Supreme Court, and the court upheld the law in 2008. This reform included a provision allowing for conscientious objection, so that was not a big deal. Then, one by one, since Mexico is a federal republic, abortion laws are a state matter. So one by one, starting in 2019, that is 12 years after the Mexico City reform, states started to decriminalize abortion. Yeah, right now, 24 out of 32 states have decriminalized abortion. Yeah, so abortion is mostly legal in the country. However, as you can imagine, there was a conservative backlash. And then for several times at the National Congress, different parties tried to pass a bill allowing for conscientious objection, which actually happened in 2018. Yet then the general health law, which is the main law on issues about health, there was this bill that was passed at Congress acknowledging an unlimited right to conscientious objection. Since the article that was passed is very short, I want to read it to you. Yeah, because it's a very nice example. Well, it's an example of how conscientious objection may be regulated. The medical and nursing staff that are part of the national health system may exercise conscientious objection and excuse themselves from participating in the provision of services established by this law. When the life of the patient is put at risk or it is a medical emergency, conscientious objection cannot be invoked. Otherwise, the cost of professional responsibility will be incurred. The exercise of conscientious objection will not lead to any type of labor discrimination. Yeah, so basically it allowed for conscientious objection whenever the healthcare provider wanted to invoke this conscientious objection, and with no consequences for this person. This is what is called conscientious absolutism. Yeah. So the National Human Rights Commission challenged this law, the constitutionality of this law. They said that, well, this cannot be allowed. This is unconstitutional. So the whole thing ended up once again at the Supreme Court of Justice in Mexico, and the case was decided on September of 2021. Yeah. What did the court rule? Well, they ruled that Article 10 bis is unconstitutional because it recognized an almost absolute right, giving a blank check to medical personnel and affecting the exercise of the reproductive rights of women and pregnant people. So at the same time, the court ruled the unconstitutionality of the criminalization of abortion. That was a very, very important decision of the court. Yeah, they said, well, all the states have to modify their constitutions and their laws if they do not allow for abortion. Yeah, because this is unconstitutional. Yeah. So some of the problems of this position of absolutism of conscience, when conscientious objection is conceived as an absolute right, the Constitution, they say, doesn't recognize absolute rights. There are no absolute rights. Yeah. Another problem is that it doesn't specify that there should be non-objecting physicians covering objectors. Does not specify deadlines to object. Does not force objectors to refer patients to non-objectors. So if a physician doesn't want to refer a patient under that law, he wouldn't have to refer this patient. Does not specify cases in which the objector can be compelled to carry out the procedure to which he or she objects. And there are also ethical objections that could be made to conscientious absolutism, because conscientious objection is constrained by the ethical constraints imposed by professional obligations of physicians. Yeah. Non-discrimination, respect the autonomy of patients, promote the health and well-being of patients, among some others. So the court sent back the whole issue to Congress, and they said, well, you have to regulate conscientious objection. Yeah, because it is not only affecting abortion. We mainly think about abortion as what conscientious objectors object to, but there are some other procedures. Yeah. in Mexico, for instance, there have been interesting cases about how physicians object to brain dead patient organ donation, for instance. Yeah. So there are three different positions on conscientious objection. One of them is the one that is exemplified by this bill that was passed, absolutism of conscience. Then there's another one that says, well, conscientious objection and the exercise of medicine are incompatible. If you're a medical doctor, you cannot invoke conscientious objection. It is your obligation to provide the service you're objecting to. That's called incompatibilism. And then there's a moderate position, a position of compromise. Yeah, this is something that is very clear in Mark Bicler's book, which I highly recommend, Conscientious Objection in Healthcare. Yeah, so many people thought at that time that the court was going to recommend an incompatibilist position. Yeah, that if it is contrary to the professional obligation of physicians and other healthcare personnel to refuse to provide any legal goods or services within the scope of their professional competence. So many people, many healthcare personnel feared that was the position that was going to take that by the Congress. Yeah. There are objections to incompatibilism. If objectors are forced, probably they will act badly. There are going to be cases of obstetric violence, for instance. Yeah, it is also hard to tell people who practice medicine to do something else. Yeah, and there is a justified, not absolute, right to conscientious objection. So the whole issue is how do you balance this right to conscientious objection with the rights of patients? Yeah. And what I want to argue now, very briefly, is that this position, incompatibilism, may be even counterproductive. And this is what the Mexican example shows. Yeah, because if you're thinking that conscientious objection should not be allowed, well, there are several bad consequences because this could create a movement of resistance to the law. And this is what has actually happened in Mexico. It could cause people who do not want to perform abortions, but are not objectors, because not every OBGYN who doesn't want to perform an abortion is an objector. Yeah, but it could cause people who do not want to perform abortions, but are not objectors, to become so. Yeah, so it could lead to civil disobedience on the part of physicians. And this is, again, what has happened in Mexico, because fearing that the court was going to go for an incompatibilist position, not allowing for conscientious objection, many physicians, many members of many healthcare personnel decided to create the Mexican Federation of Conscientious Objectors, EMOC. Yeah, this is their website. So Congress called for public hearings in 2022. Yeah, and then since there was this social and political movement, the MOC, then the whole issue was frozen at Congress. Yeah, a bill regulating conscientious objection, which was actually not incompatibilist, but it was more what I would call a compromise position. Yeah, allowing for conscientious objection, but with certain regulations. Yeah, the bill has been stuck in Congress ever since then. Yeah, so the situation right now in Mexico is that we don't have a law regulating for conscientious objection at the national level. Yeah, so this is basically what I wanted to share with you. Yeah, if there's something to be learned about the Mexican case, is that conscientious objection has to be regulated, but in a way that allows for that recognizes the right to conscientious objection, at the same time recognizing the rights of patients. Yeah. So this is basically what I wanted to share with you. Yeah. I hope I'm doing fine in terms of time. Yeah. So back to you, Jamie. Thank you.
Thank you so much, Gustavo. Finally, we'll turn to Dr. Ana Horvat-Vukovic, a professor of law at the University of Zagreb. Her main interest has long been anti-discrimination law through the anti-subordination lens, particularly avenues of achieving and safeguarding substantive equality of political minorities such as women, the LGBTIQA plus community, and racial and ethnic minorities. The issues of equal citizenship, personal autonomy, self-determination, and dignity center in her research, be it when dealing with fundamental human rights or issues of federalist theory. Dr. Horvat-Vukovic is a longstanding academic advisor for the Free Legal Advice Center at the Zagreb University Faculty of Law, a member of the Ombudswoman's Council for Human Rights, and as the administrative board chair of the City of Zagreb's Shelter for Victims of Domestic Violence. I turn it to you.
Thank you, Jamie. What do we say in English? Last but not the least, thank you, everybody. You've had a lot of patience until now, and I hope you suffer through 7 minutes, hopefully, of the creation regulation. So I don't have a PowerPoint presentation. I have prepared some short notes so I don't go off script, as we professors are wont to do, as you know. So, just like a brief introduction, just like all of the rest of the ex-Yugoslav states, Croatia was actually one of the first countries in the world to constitutionalize the right to abortion in 1974, so over half a decade ago. And we legalized it, we codified it in law in 1978, so the abortion has been legal up to 12 weeks of pregnancy. And even after that, but under some indications, if the pregnancy is a result of a crime, if a mother's life and health are in danger, or if there's a severe fetal malformation, then there is no time limit, of course, but otherwise it's 12 weeks of pregnancy. Even after we transitioned into democracy in 1990 and our new constitution left the right to abortion out, but the 1978 law remained in place, and its constitutionality was confirmed in 2017, actually, by the Constitutional Court's decision, even if, and I have to tell you this, the proceedings took 27 years. From 1990 to 2017. But finally, it confirmed that, yes, the 1978 Act still stands, our transition from socialism to democracy notwithstanding. And the Constitutional Court affirmed the right to abortion to be rooted in a host of fundamental freedoms, primarily those of privacy and dignity. So, since Croatia is a member of the Council of Europe, not only the European Union, but also the Council of Europe, and the ECHR has a quasi-constitutional status in the legal hierarchy, also including the case law of the European Court of Human Rights, we are bound not only by the constitutional, but also the ECHR obligations. So, the Croatian state has a positive obligation to make access to abortion practical and effective, not only theoretical and illusory, because it has expressly legalized such a right. So now, of course, it cannot turn a blind eye to its very own commitment. So also, given the fact that, as the previous speakers also underlined, public hospitals in Croatia have a monopoly on providing abortion services. The doctors have a fiduciary obligation to their patients. Practical access to abortion, as we know, holds a clear gender dimension implications. So the state has to do all it can to ensure the right to abortion, conscientious objection notwithstanding. So the very right to abortion in Croatia is not in question per se, but the conscientious objection is a major obstacle in this sense. Because unlike in Sweden, and we've seen the European Court of Human Rights confirm that Sweden has the right to exclude conscientious objection in 2 cases, the Grimark and Steen cases, In Croatia, conscientious objection is a constitutionally guaranteed right under Article 40. And moreover, not only that, but the right to religious freedom and the freedom of conscience it entails, which are analogous to ECHR's Article 9, actually virtually identical, because we actually copy-pasted it. This is part of Croatia's constitutional identity. So it's not only part of the constitution, but it's also part of the Croatia's constitutional identity, which means the body of the unamendable provisions of the Croatian constitution. And conscientious objection is also legally guaranteed in Croatia to physicians and nurses, barring emergencies when abortion and other reproductive health care has to be provided. So this means that the state can limit conscientious objection, but because it belongs to the constitutional identity code, it can do so only under very strict scrutiny, meaning a reduced margin of discretion for the state, and only when the state can show a pressing social need. That means necessity and lack of less restrictive means to protect women's access to abortion. So, where do we stand in practice? The state does nothing to curb the conscientious objection. There is de facto a massively restricted access to abortion, particularly among rural women, among indigenous women, among victims of domestic violence, not only due to a large number of objectors, but also due to the high cost of abortion, because the minimum wage in Croatia is currently set at 560 euros, while abortion costs from 350 euros onwards. So that is more than half of the minimum paycheck in Croatia. Most recent data shows that almost 60% of OBGYNs claims conscientious objection, almost 60%. A large number of anesthesiologists, 14% of midwives, and over half of them say that they would also claim a conscientious objection if they were not worried about the implications for their future careers. And mind you, this is not only relating to care directly entailing pregnancy termination. This is also care that simply evokes moral complicity claims, like they refuse postnatal care for IVF babies, or they refuse participation in birth control education. There are general practitioners who refuse to refer their patients for IVF. There are pharmacists who refuse to issue emergency contraceptives or to issue birth control. 20% of hospitals invoke institutional conscientious objection. So that's 1/5 of hospitals, and abortion, as I said, can only be provided in public hospitals, not in private practice. Some of these hospitals who employ the institutional conscientious objection do contract it out, so they employ outside contractors, but this is, again, paid for by the Croatian taxpayers who have already funded the objecting OBGYN's paychecks. The objecting OBGYNs in hospitals often, very often, do not respect their nominally statutory duty to refer or to provide information about access to abortion. What's particularly worrisome for me as a constitutional scholar is that the state tolerates professional associations of pharmacists and midwives' unconstitutional codes of conduct, where they have illegally self-authorized themselves, their members, to claim conscientious objection against the specific laws that we have. Our laws only allow for a conscientious objection of physicians and nurses. There's no mention of pharmacists or midwives, etc. And finally, and this has been the most recent development, some 3 years ago, we found out, the public at large at least, that due to rampant conscientious objections, there are 0 OBGYNs in the country who can perform an abortion past the fetal viability threshold. This forces women to seek abortion in a neighboring country of Slovenia, where this type of abortion is accessible and very humane, from what I hear. And the kick is that the statutory healthcare insurance fund in Croatia then reimburses these women for their travel costs and for the cost of their abortion in Slovenia, which they cannot get in Croatia because there is no possibility for them to be educated on how to stop the fetus's heart in utero by applying the potassium chloride injection, et cetera, et cetera. So we found, as I said, the public at large found this out only in 2022, because in that year, a very, very brave woman by the name of Mirela Chaveda has made her fight public. She was at that time an expectant mother, pregnant with a terminally ill baby with a galloping teratoma. And she was advised by the Croatian hospitals that she couldn't get an abortion that she needed because she was at that point 26 weeks pregnant. And that was past the fetal viability threshold, because they did not know how to perform such an abortion. But she could be induced early, give birth, and then wait for the baby to essentially die or expire. That is the option that they gave her. In my opinion, and I gave my professional opinion, and I don't know if she will ever follow up on it, but I did state that this is a very clear violation of the constitutional and of the conventional prohibition of torture and of inhuman treatment, and that she has every ground to sue Croatia before the Strasbourg Court of Human Rights for human rights violations in this sense, because such an abortion is not an option, and this is an outright actually denial of any abortion care for such women in such dire circumstances and situations. So this would be it from my side. I'm looking forward to any questions, any clarifications that I can give, and I thank all of my co-participants for their presentations. I always learn so much, and I'm so grateful to be part of this wonderful group. Thank you. Also, Jamie.
Thank you so much, Anna. It has been an absolute pleasure to have all of our speakers present on this very important topic. Unfortunately, we've run out of time for questions, but we invite colleagues to share questions, and we will address them in our next upcoming webinar. Again, this will take place in October, and our third webinar will take place in November. We will be sharing a recording of this webinar along with the resources that we've shared in the chat. And we, again, thank each and every one of the panelists here for your dedication and your work and your time that you've taken out today to share your important perspectives. We look forward to continuing this discussion, and we thank the audience for joining in. Have a great day. Thank you.
Thanks, Jamie. Thanks, everyone. To be continued.
Thank you.